The third case on the docket for Wednesday, December 15th, 2021 is Appeal Number 122582, Delaware Township and High Prairie Township versus the City of Lansing, Kansas, and Leavenworth County, Kansas, and the Leavenworth County Board of Commissioners. Leavenworth County briefs both sides. We are ready to proceed, Your Honor.
Counsel, I'd ask that you approach the lectern one at a time and enter your appearances and then return to the council table.
May it please the court, Adam Hall for the City of Lansing, ready for argument.
May it please the court, Todd Thompson as co-counsel for the City of Lansing, ready for argument.
May it please the court, Tim Orick on behalf of the Appalese, Delaware Township, High Prairie Township, and the Leavenworth County Board of Commissioners. Ready for argument.
Paul, I understand that you will be starting the argument. Is that correct?
That is correct, and I would request 5 minutes of rebuttal.
All right, 5 minutes is granted. And then you want to split with Mr. Thompson?
That's also the request. Principal argument, I would request 8 minutes, 2 minutes for Mr. Thompson.
All right, that's granted.
May it please the court, this is a civil case that involves a dispute that arises between governmental entities in Leavenworth County, Kansas. In 2003, the City of Lansing and its municipal neighbors, the Townships of Delaware and High Prairie, decided to enter into an interlocal cooperation agreement, a sort of contract between municipal entities with the purpose of fire protection. And through their agreement and with the cooperation of the Board of County Commissioners of Leavenworth County, Kansas, they created a new fire protection entity called Fire District Number 1 within Leavenworth County. The agreement had terms for governance of Fire District 1, including its use of property, which at the time of the initiation of the agreement, of the initiation of Fire District 1, was owned by some of those municipal partners. It included what would ultimately happen if the agreement was terminated. Specifically, it had a provision for the termination by notice by any one party to the agreement, followed by a provision for the disposition of property, which was then owned by the fire district itself. The city asked this court to do what every Kansas court is charged to do in contract disputes, which is enforce the contract on its terms if reasonably possible to do so. The termination and property disposal provisions of the party's contract are lawful, so this court should enforce them. They're lawful both in the sense that they're permissible, but they're also lawful, more importantly, because they're expressly required by Kansas's Interlocal Cooperation Act. Unfortunately, the lower courts did not give this contract effect and effectively thwarted its purposes and provisions. And that's something that this court has repeatedly instructed the lower courts not to do. So that's not a mistake to be repeated. The city also asked the court to interpret KSA 1936-12A, subsection B, to mean what it says, which is that a fire district board of trustees chosen by a joint board pursuant to an interlocal agreement like the party's interlocal agreement is vested with those powers which are ordinarily vested in the Board of County Commissioners. All those powers in the statutory subsections of 1936-01 to 1936-06, including the authority to alter or remove lands from the fire district. The district court and the Court of Appeals both indicated in their opinions that that consequence would be unacceptable. The Court of Appeals referred to that as an unlawful delegation of the county commissioners' plenary powers over fire districts. The district court simply characterized the potential result of that plain reading of the statute as unacceptable. But I think it's clear within the statute itself that that was the exact consequence that was intended by the legislature. And I think this court has to reach that conclusion by virtue of a plain reading of the language of the statute.
That would include the petition provisions as well?
It would. There's no question that the statute lists a set of statutes that are included within the powers which are delegated, not frankly by the Board of County Commissioners to the Board of Trustees, but by the legislature to the Board of Trustees in the statute. The Board of County Commissioners just delegates its authority to appoint the Board of Trustees. The automatic delegation from the legislature of all the powers then is done by, as a matter of law. The issues from the city's perspective come to this court because of a conflation of matters below. The city of Lansing issued a notice to terminate the parties' interlocal agreement. That termination, that word has significance, to end the interlocal agreement contract. Well, in the petition to the district court below for declaratory judgment and thereafter, that has been recharacterized. That termination of the interlocal agreement contract has been recharacterized as seeking a disorganization or alteration of the governmental entity of the fire district itself. But that's not what the genesis of the parties' disagreement was. The only thing that began this disagreement was an issuance of a notice to terminate the particular agreement the parties had for the governance of that fire district. And that was the question.
I'm not sure I understand that. And so let me tell you what kind of drove me crazy reading all this stuff. So first of all, at the beginning, the city of Lansing could not be forced into a fire district. It had to consent, as I read the law. Is that correct?
I agree with that.
And so they did. And they did it under an agreement that had the exit provisions, the ability to terminate this agreement, okay? And the county, when it created the fire district, it incorporated by reference that interlocal agreement which had the termination provisions in it, okay? So it seems to me it's pretty clear that the ability to terminate was agreed to by everyone. I'm having difficulty under the law, though, making that termination provision effective. Because it seems like once you create this governmental animal, even if it's under a misunderstanding of the law, and I realize the Attorney General signed off on this, but I'm trying to figure out whether it's possible to terminate this fire district as was contemplated once it gets created under law. Does that make sense?
That's the conflation. So the question is twofold. The fire district will remain. If the contract, the interlocal agreement, which was concurrent with the creation of the fire district, is eliminated, and the property of the fire district is distributed to its constituent members pursuant to the termination provision, the entity remains. It remains a taxing political body. There will still be the city of Lansing within its geographic boundaries and the 2 townships within its geographic boundaries. It will have a system of governance. Since the delegation of the Board of County Commissioners to the joint board came pursuant to the interlocal agreement, in the absence of the interlocal agreement, the governance would return to the Board of County Commissioners.
So in order to effect the termination, though, is it enough that the city of Lansing voted its, let me label it your contractual right to exit? Is that enough, or does something else have to happen?
Something
specifically
else.
by the county commission?
In response to your first statement, Your Honor, something else has to happen. The second statement, I think that question remains open.
And so you're saying that it's possible that the Board of Trustees can affect your termination?
That's correct.
And that, so the power, what if they say no?
I think the city, again, I don't want to get too far afield on this point because I think that was part of the error of the lower courts is they're trying to reason out how ultimately there may be a dissolution or disorganization or alteration of the fire district as a governmental entity. When the question sort of squarely presented is, can Lansing terminate the interlocal agreement, which is sort of an overlay on that governmental entity, and reap the contractual benefits which it had bargained for at the beginning of the creation of the fire district entity. So I think the city of Lansing, because you asked the question, hypothetically, could petition while the delegation remains by the joint board to the Board of Trustees, petition the Board of Trustees to permit its lands to be excluded. I think the city of Lansing could, by charter ordinance, seek to exclude itself from the fire district
Yeah, and I don't want to
statutes.
get into the home rule stuff because that gives everybody a headache when you get into the home rule stuff. I'm really trying to focus on the creation of the fire district, which clearly envisioned the city's ability to terminate this deal by its terms. I'm just wondering whether those contractual provisions are legal and have any legal effect. You know, and so then I went through this exercise, well, okay, they don't, we sever them, or can we sever them, or does it make the whole organization of the fire district invalid ab initio? And I mean, this is the way I've played this thing out. And I still keep bumping up against, I now have a governmental entity, and that's the fire district. I don't see how the fire district gets reconstituted under the law just because the city wants, as opposed to the whole fire district goes away and you have to redo it again.
I'm out of time, but I can answer your question if you'll permit me. So I think that question is probably best answered in the City of Lansing supplemental brief beginning at page 11. And it just goes into page 12. But the bullet points are, upon the termination of the interlocal agreement, the strict terms of the interlocal agreement are followed. The agreement terminates. The property is divided between the constituent entities of the fire district. The fire district remains. The governance of the fire district would be by virtue of the Board of County Commissioners. And I think the concern of the Court of Appeals was, well, who knows what these entities will do? Like, maybe they'll sell off the fire equipment to which they are apportioned. But what is to be remembered is they're still subject to the taxation of the fire district. They are still within the fire district's protection radius. Each of those municipalities that is a part of the fire district has every incentive to provide, by lease or otherwise, its allocated fire protection equipment for the common protection of their respective municipal entities. Because until there is something different, they will still require fire protection, and they will still be taxed for it.
One possible way to rephrase Justice Biles's questions, possibly, is, just in pure terms of contract, can the interlocal agreement bind a non-party? And is the fire district a non-party to the contract?
I think it can.
And what do you cite as your authority for the proposition that, as a matter of contract law, this contract can bind a non-party that didn't agree to the terms?
So, a couple of responses. The first one is the non-party that Your Honor speaks of was created by virtue of the existence of the interlocal agreement. So it's a product of
Well, the
interlocal
agreement may have been necessary but not sufficient by itself to create the district. Is that a proper statement of law in your view? Something else had to happen in addition to the interlocal agreement.
You had to have the county. I mean, the county had to agree to this after you had done the interlocal.
So as I read the Interlocal Cooperation Act, I think that these municipal entities could have come together themselves and created a new entity that would be in effectively a fire district.
But doesn't the board have to delegate its powers to that to function in the way you're asking us to have it function?
Under the particular way that these municipal entities proceeded, I agree that in order to invoke 1936-12A subsection B, that there would have to be a delegation from the Board of County Commissioners, thus bringing in all of the statutes pertaining to that. But that was the first answer. The second answer is the statutes seem to contemplate the existence of an entity which results from the use of an interlocal agreement. And in the event that the interlocal agreement terminates, the Interlocal Agreement Act, if it's to be read, its other provisions to be read in pari materia, I think requires that there be a disposition of that created entity's property to its constituent members. And that statute for looking up statutes on the fly. Is 122904A, speaking of the creation of a separate entity. I think the legislature had contemplated this sort of a situation.
Where in the statute, the statute you just cited, 1936-12AB, it clearly contemplates authority to create, but where does it provide the authority to terminate or alter the agreement once it's in place? I don't see it there or anywhere.
So if you're speaking of 1936-12A, subsection B, that subsection is within a statute which generally authorizes a fire district to delegate its powers to a board of trustees. Subsection B was enacted in 2003, shortly before the creation of this fire district entity. Its purpose was to allow, through interlocal agreement, the parties to cause that delegation and get a board of trustees that they controlled that had all the powers of the Board of County Commissioners. At the flush language below subsection B, it says, an interlocal agreement entered into pursuant to this subsection shall be subject to the provisions of KSA 12-2901 et sec and amendments thereto, which is an incorporation by reference of the Interlocal Agreement Act.
Is it a fair characterization of your argument to say that you're effectively suggesting that there are no quote-unquote non-parties to the interlocal agreement?
I think that is a fair characterization of the issue.
What is the practical effect of, I mean, you would talk about conflation and conflating the issues. What is the practical effect of no interlocal agreement, dissolving that, but still having a fire district?
So when the parties, this is an answer, I promise. When the parties formed their fire district, the fire district didn't own any property. The parties variously owned, Delaware Township owned a fire station. There was plans if they got together to build a new fire station in High Prairie Township. And there was a provision within the interlocal agreement that said, okay, over time, the Delaware fire station will become the property of the fire district we are to create. Over time, the High Prairie Township fire station will become property of the fire district we create. In many ways, the parties would just go back to that point of the fire district's genesis, that different parties own the property which is being utilized by the fire district instead of the fire district owning that property. And the parties, the thing that also I think sort of got missed by the lower courts is the parties bargained for an extensive notice period, 18 months, so that they could figure out what it is that they wanted to do. And those provisions are for everyone's protection within the fire district, to make sure that all of the concerns of, I think, this court and the lower courts are addressed by the parties through the appropriate political and bargaining process, and not.
What is the end game here for the city of Lansing? What's going to be the difference between before, when they were part of an interlocal agreement, and after, when they're not part of an interlocal? What's the end game?
So I think they would have the option to negotiate with the townships for fire protection. I think they would have a greater bargaining position if they actually have ownership of the part of the fire district's property. I think they could choose to start as other municipal cities of their size in the county of Leavenworth, provide their own fire protection. I think it gives the city options. Because the interlocal agreement, interlocal cooperation agreement, in its sort of statement of purpose, says the purpose of this act is to allow all of these entities to come together for their common purpose, for the efficient use, and it talks about the efficient use of governmental power and authority. And over time, that changes. The needs of the municipal entities, the constituent members of the fire district have changed. And so the city of Lansing says something needs to give, and it has exercised its contractual authority to try and make that change.
So what happens to the fire district board itself? It no longer, it dissolves along with the termination of the interlocal agreement?
It would, and its authority would revert to the Board of County Commissioners.
And the fire district's existing fire protection service agreements with the various localities within the larger district, what happens to those agreements? Were those agreements entered into by the fire district board of trustees and the various entities? Or how do those fire protection agreements, who are the parties to those agreements?
So they don't exist currently. They would materialize in the 18-month notice period. But again,
Oh, there are no existing fire protection service agreements?
between the interlocal agreement is that.
That serves, there are no independent agreements outside of that interlocal agreement in terms of how and when we provide fire protection services to different areas within the district?
I don't have any evidence of that in the record or from my independent knowledge.
Okay.
But it's about options and not locking the city of Lansing into continuing in this one particular form of fire protection. It's now, the city of Lansing has grown tremendously. Its needs are different. And the only way to effectuate change in that context is to permit the city of Lansing the benefit of its bargain. And I understand the concern of judges to enforce contracts that have an effect or potential effect on fire protection, which is a very important subject matter. But in this instance, there's an 18-month notice period, and the individual constituent members of the fire district have every incentive to protect their own citizens using that equipment, which is to be allocated to them, and plan for the fire protection of their geographic areas.
I'm a little late to this because home rule was a little late to this. Judge King raised home rule on page 23 and 24 of his opinion when he mistakenly said that the county has exclusive control over this. That is simply not true. That's not what home rule constitutionally provides to the cities. The cities have the right to have the greatest possible control over their activities. That has been precluded here by a couple of things. One, the city did not assert in the strongest possible way its powers because it wanted to work this out through negotiations during the 18-month period. It could have done a charter ordinance. It did not do that. It could have gone ahead and filed the petitions it had with the Board of Trustees and had the board, not the commission, not the county commission, but the board, exclude the lands from the fire district. It chose not to do that, in part because of the delays that occurred because of the township's lawsuit. But the city had that authority and has that home rule power. And it simply, unfortunately, it now turns out, opted to try and negotiate with townships that were unwilling to follow the contractual agreement that they went through. So the city still has its home rule powers. It can still act on that. But we need direction, just as the league said, from this court to tell the district court that it does not have the authority to countermand the contractual agreement that was entered into here. So
Walk me through, counsel, how this home rule issue isn't asking for an advisory opinion. I'm really having difficulty understanding why we're supposed to answer that question.
Sure.
Knowing
Because
that I don't want to answer it because it gives me a headache, but I'm really serious about, to me, this looks like we're being asked to approve something else that hasn't happened.
I disagree with that because Judge King, in his opinion, and the Court of Appeals, in its opinion, both said that the county has exclusive control over this fire district and the procedures of the fire district. And that is simply not true. It's not true because the fire district statutes are not uniformly applicable. So you have two courts, the two lower courts have made an error in saying that the fire district statutes are uniformly applicable. They are not. There's a special section for Johnson County cities. There's a special section for just second and third class cities. So in no way is that article uniformly applicable to all cities. So that's the error that you need to address and correct. It's not advisory. And the league didn't ask for an advisory opinion. The league asked you to fix the problem. So it's not advisory. It's a real error by the two lower courts.
Why doesn't the county have exclusive control over the fire district? Because the county's the entity that created the fire district. Not because of home rule, but just because of the facts of this case.
Well, because the statute says that under Section B, if you set it up that way, then all of those powers from 3601 to 3606.
So you're hinging, I mean, it seems to me that the entire argument made by this side of the case hinges on that statute, which is 3612A subsection B. Is that correct?
Correct. And
Okay,
it
so my
says,
specific question would be then, why does that statute apply when it requires that the interlocal agreement be entered into by the Board of County Commissioners? And that's not a fact. That didn't happen here, as I understand.
what do you mean it didn't happen?
Or did it?
Oh, absolutely. The Board of County Commissioners passed a resolution entering into this interlocal agreement. They are a party.
They're a party.
And so is the Attorney General.
Okay. And so when the Court of Appeals discusses this, this is one area where I got somewhat confused. The Court of Appeals only mentions the other municipalities as parties to the agreement.
And there's plenty of reasons to be confused by both the Court of Appeals opinion and by Judge King's opinion. So I'm sympathetic with that. But the fact is, they're all...
But just to be clear, your position is clearly that the board, that the county is a party to the agreement.
Yes.
Okay.
And again, so they contractually entered into an agreement which the statute says all of your powers between 3601 and 3606 go to the Board of Trustees. Are there any other questions? Thank you.
Again, Tim Orick for the Appalese, Delaware Township, High Prairie Township, and the Board of County Commissioners. Couple places I'd like to start. I'm going to start by trying to get rid of this home rule argument. The reason home rule was late to the party is that it was never raised until City of Lansing asked the court on a 60-259 motion to alter or amend the judgment. Home rule came up for the very first time. And Judge King noted it's really too late. But he did address it in his argument. But more importantly, this fire district was created pursuant to 1936-01. It is all over all of the organizational documents. You will not find one word mentioning, asserting, reserving, addressing the City of Lansing's home rule power. The initial resolution of the Board of County Commissioners stating an intent to form the fire district stated specifically it was to be done pursuant to 1936-01. The City of Lansing's own resolution opting in, voluntarily opting in to become a member of this fire district specifically states that is pursuant to 1936-01 et sec. And then the interlocal agreement says it is being entered into pursuant to 1936-01 et sec.
Well, let me stop you there, counsel, I mean, I'm looking at it. It says the agreement's being entered into pursuant to 122901, the interlocal agreement.
The interlocal agreement being entered into pursuant to the statutes that allow for interlocal agreements. But that's not an assertion of the home rule power.
I agree, it's not, I agree with that. I'm just saying that, I mean, when I started this thing thinking that this was entirely under the Chapter 19 provisions, but this interlocal comes up and it says it's under Chapter 12. So, you know, then I had to chase that rabbit to decide whether that means anything or not.
Well, they all must be read together. Okay, certainly. 1936-01 was the enabling legislation that allowed the county to proceed in the first instance to state an intent to form the district. And then 1936-12A allows for interlocal agreements to be entered as part of that exercise. And then in turn, the Interlocal Agreement Act, of course, does provide provisions that state that it must define the duration of the agreement and what would happen to all the property.
Given that, and it sounds as though you've helped clarify my earlier question, you don't dispute that the county was a part of the agreement.
No, absolutely they were part of it.
And so if everyone's part of the agreement, why doesn't the agreement just control?
Because the terms of the agreement that provide for the termination of the agreement, together with the disposition of all the property, the assets, and the liabilities of the agreement are contrary to 1936-04, which provide for the disorganization of the district or the removal of territory from the district. And
How can that be the case when 2904D expressly says that the interlocal agreement is supposed to include terms that set forth the method of termination and the method of disposal of property?
in this case, we have a specific statutes, 1936-04, that deal with the specific procedures for dissolving a fire district formed pursuant to 1936-01. Now, 12,
Doesn't this refer to termination of the agreement and distribution of the property, and not necessarily changing the fire district itself, which is subject to requirements of publication, allowance of protest, et cetera?
I think this court needs to do one important thing and answer that question. I would remind the court that this case was submitted to the district court on stipulated facts and documents. And of course, when that is the case, the appellate courts have de novo review and are allowed to interpret those documents. However, I think in doing so, you would be wise to look at the analysis of both the district court and the Court of Appeals, because they both concluded that the city of Lansing trying to do something more here than just terminate an agreement. If you look at the notice of termination, and that is at page 90 of volume 1, it specifically says we plan to start our own municipal fire department with all the property we're going to take from the fire district.
Like the
So
fire
both-
trucks and the other things that were owned separately when the agreement was formed, and now you own them jointly.
The fire district owns them, owns all that equipment.
And they want to do away with that. They want to distribute the property based on the value of the assets, the value of the liabilities. Everybody go their own way and own their own things, and then we'll go forward, correct?
Alone.
What's wrong?
They said they are going to go forward without y'all. Maybe we'll provide fire protection to you.
I guess my question is, so what? I mean, that's what everyone agreed to.
It is, but doing that is, as the district court and the Court of Appeals said, was basically a de facto disorganization, or the city is leaving.
But didn't the parties
And-
contemplate that? In 10A, they talk about disorganization by the board under 1936-04. But in B and C, they talk about termination and disposition of the property.
Right, but-
It at least seems to convey an understanding by the party that there's some space between those two things.
But nobody accounted for following 1936-04B, which is when one entity wants to leave, alter the territory of the district, there is a very specific statutory process to accomplish that. And so our position is that because the interlocal agreement failed to follow, and the effort to remove themselves from the district failed to follow either the disorganization proceedings under 3604A or the proceedings under 3604B.
Why can't
so-
they do that? Why can't they do that, if that construction is correct, why can't they do that down the road? Step one, terminate the interlocal agreement. And that doesn't, according to their position, disorganize or alter the territories of the fire district. That may be another step that has to happen down the road under 3604.
It leaves an empty shell that has nothing, no property, no assets, no ability to fulfill its function.
Why do you say that? The property is still there. It's simply owned separately.
If we look at the city's notice, it is not intending to stay in Fire District Number 1. It is intending to start its own municipal fire department with the property and the equipment that formerly belonged to the fire district.
You're just
Could I
saying.
go back to my question? It appears to me that the parties contemplated that that could happen and recognized that one of those entities could pull out and they would be left to then have to reform.
Oh,
I just don't know how else you reconcile what the parties agreed to and
all we're saying is that the parties agreed to a alteration, somebody leaving the district, under a procedure that's not authorized by statute.
Which means that these provisions were entered into under some huge mistake of law, right? Because the
They are,
city
correct, they are illegal.
granting its consent, you can't pull this city into a fire district, they've got a consent.
Correct.
They gave their consent, but they also got, in exchange for that, termination provisions. And, you know, and you got a ton of lawyers signing off on this, and the Attorney General's signing off on and all that, but still, you're saying that those provisions that induced this consent and induced the creation of the fire district is all premised on a huge mistake of law. And I can get there. The question is what to do about it.
Well, and I'm having trouble getting there, so,
Well,
but answer that question first.
Sure.
Kyle's question
Well,
first.
again, very elementary rule of contract enforcement is you cannot enforce a contract that's contrary to public policy. Contracts that violate state law, that are contrary to state law, violate public policy. And therefore, that's an illegal provision, not illegal in the criminal sense, but it is a mistake of law that these parties entered into an agreement that was contrary to what the statutes clearly contemplated was the manner in which these entities could be either disorganized or somebody leave. And here's the thing, the legislature created these procedures for a reason. And we can all say that they created a high bar if you want to leave, but that is what the legislature did, recognizing that once you get into a fire district and everybody's resources are poured in there, nearly 20 years of operation without problem, if you want to bust that up, you got to follow the statutes. And you can't just say, we're going to give notice and we're done. Just giving notice does not follow the provisions of 1936-04, A or B. They've got the
Doesn't,
opportunity to try to accomplish what they're trying to accomplish. All they have to do is comply with the statute. And so in this instance, the termination provisions that are required by the Interlocal Cooperation Act have to, in this narrow instance, conform to the enabling legislation that both sets the process for creating and for disbanding.
But doesn't 3604 basically just say there will be a fire district and it will contain this territory? In B talking about the annexation or the de-annexation of territory. Why does it go any further than that? And so it could end up, and it appears that the parties may have contemplated, that it could end up being a shell or at least a district that had different membership than it originally did, allowing members to come and go without disorganizing the fire district or even de-annexing any property.
Yeah,
Isn't that
well,
where we are?
I mean, yeah, I think this is a case of nobody was thinking ahead to the divorce. You
And I
know, when
just
they
don't-
entered into this agreement, we're all getting married.
And under that reading of 1936-04, I'm having trouble seeing why this was illegal, why this was contrary to those statutes.
Because the statute requires to disorganize the district.
But I'm not, I think the parties contemplated that this would not be a disorganization. It would just be a change.
At a minimum, it would be the city of Lansing leaving the district,
Their territories-
thereby altering the territory of the district, and to do that, you have to comply with subsection B of 3604.
But that's my point. I don't know that that happens. I mean, their territory still remains within the district. And that may be a collateral impact. They may even have their taxpayers taxed twice. I don't know. But that's, to me, something different than what this seems to contemplate, to say, no, they no longer necessarily will be a part of the rest of the agreement.
Again, I think looking at the practical effect of a contract provision that says by giving notice and enforcing the apportionment of assets, property, equipment, liabilities, you're leaving nothing behind. And therefore, I don't think the court can ignore the practical effect of what that is. As the Court of Appeals said, as the district court said, at a minimum, that's an entity trying to alter the territory of the district and arguably to disorganize it completely. I mean, to leave an empty shell there that has no ability to do its job, I don't know what that is if it's not disorganizing it.
Sorry, I don't understand what you mean by empty shell.
The interlocal agreement and the notice that Lansing gave to the townships and to the Board of Commissioners said, we are ready to enter into negotiations to apportion the property, equipment, assets, liabilities. Because it leaves nothing behind. Fire District Number 1 is an entity in name only.
The assets become disposed to the parties to the agreement and are no longer owned by the fire district itself.
Correct.
As effective termination.
Exactly.
But those entities that remain have the ability to form a new contract, a new interlocal agreement, a new agreement to have jointly owned property.
And the city's notice stated it had no intent of doing so. That it was going to form a municipal district, it would be willing to provide fire service to the townships under a contract or a lease.
But the termination of the interlocal agreement arguably leaves the fire district in place as it currently exists. Does it also retain its taxing powers to tax all the members within that existing district?
Suppose it would, but you're starting from scratch. I'm out of time. I'd be happy to entertain any additional questions. Thank you.
Thank you, Mr. Wright.
I'm going to address some arguments made by Mr. Orrick on behalf of the appellees. Mr. Orrick indicated that the city of Lansing raised the issue of home rule for the first time on alteration or amendment of judgment, and that is correct. But the reason for that was the judge raised it on his own motion in the course of his opinion related to the termination of the interlocal agreement. And in doing so, he based part of his judgment on a hypothetical question not posed by the parties. And that begins, by the way, on page 23 of his opinion, where he says these fire district statutes are statutes of uniform application within the meaning of Article 12, Section 5. And Justice Biles, I think, mentioned, well, how are we not just offering an advisory opinion? I think that statement by the district court should be corrected by this court. It seems very clear from the brief of the amicus that that's incorrect. Specifically, within Article 36 of Chapter 19, there are provisions which pertain only to fire districts within certain geographic areas of the state of Kansas. It sort of necessarily is not an enactment of uniform application within the state of Kansas.
But did that principle carry through over to the Court of Appeals? I thought they washed their hands of it. It's unnecessary to reach the arguments about home rule at the, at the last paragraph of the opinion. And so they didn't do anything with it.
Candidly,
Looking at it for errors that they committed based on the petitions for review and that kind of thing.
candidly,
I think reaching down to, oh, by the way, something the district court said, let's just take care of that while we're here kind of thing, sounds to me like an advisory opinion.
And I would agree that advisory opinions are outside this court's jurisdiction. You have to decide cases and controversies. But I think through the development of argument, the court has become aware that there are a number of options that the city of Lansing may exercise in order to fix the final governmental entity and agreement or agreements that will make up fire protection in that area, which is now Fire District 1, if this court authorizes the interlocal agreement to terminate and terminate according to its terms. And one of the ways that the city of Lansing might exit the fire district would be through use of its home rule powers. And if the district court has declared that that is not an option available to the city of Lansing based on an erroneous statement regarding a statewide set of laws that has never been interpreted by this court before, it might do so with some degree of authority. I think particularly because these are matters of first impression with regard to most of these fire district statutes, that it's something that this court ought, and looks like is going to be an issue between the parties.
Isn't your use of the word might, doesn't that give away the whole advisory opinion question?
It is hypothetical. I mean, it certainly is. And now, this is a declaratory judgment action, so to the extent the court has case or controversy jurisdiction, it's sort of at its zenith. And it is something that I think both parties have basically conceded to the court was contemplated or potentially is contemplated as part of the exit strategy. But that would be the request of the city.
But you're saying it should not be part of this case or controversy?
In the view of the city, it's not. I'm envisioning if there is a remand and the city decides to invoke its constitutional home rule authority, that there will be some argument of estoppel or some argument of preclusion or law of the case that might prevent the city from doing that based on a then unreviewable decision made by the district court. That's all I seek to avoid. It's important, so there was some discussion of the empty shell of the fire district. The fire district will remain. Its taxing authority will remain. It will have a governing body. That will be the Board of County Commissioners if this court enforces the contract according to its terms. And its entities, the city of Lansing will still be in it. There was lots of discussion about the illegal use of the interlocal agreement and its termination provisions to exit the fire district. The city of Lansing has not contended that it is able to exit the fire district by virtue of terminating the interlocal agreement. And that's the issue which I began with an argument, the conflation issue. The termination of the agreement is not an exit for the city of Lansing. It is just a change in the structure of the governance of the fire district, and it sort of creates an opportunity for the parties to renegotiate their respective positions and their needs so that they can, consistent with the purposes of the Interlocal Agreements Act, enter into a new agreement or not, in their interest and in the interest of their constituencies in northeast Leavenworth, Kansas.
Thank you, Mr. Paul. Thank you to all counsel for your arguments in this matter. We will take this appeal under advisement.